So a very good evening and warm welcome to Kaho's Doctors' Day celebration. Today, we not only honor the commitment and compassion of doctors across the globe, but we also dwell deep into the evolving conversation around informed consent in medical practice and law. May I request, Mr. We are privileged to have with us a galaxy of brilliant minds from medicine, law, and healthcare policy. This evening promises insight, reflection, and engaging discussion, plus a dash of fun through interactive quiz. Let's begin with this special occasion with a welcome address from a luminary in Indian ophthalmology, Professor Dr. Nirmal Frederick. Dr. Frederick is a chief eye surgeon and MD at Nirmal's Eye Hospital, Chennai. With over 40 years of clinical experience, he has chaired National Medical Board, authored NABH eye care standards, and delivered more than 1,400 lectures globally. He is a proud recipient of Kaho's Quality Champion Award. Dr. Frederick set an example of excellence. We welcome you, sir, and give us an introduction. Thank you.
Thank you, Danya, for the kind introduction and kind words. Dear friends and colleagues, happy Doctors' Day to everyone. Welcome to this special webinar on Doctors' Day on informed consent in medical practice and law. As William Osler beautifully said, a good physician treats the disease and a great physician treats the patient who has the disease. Today, we explore how we can be even better at treating our patients with respect and understanding. So let me share a quick story which recently happened in my clinic. The patient attender asked me, "Doctor, can you explain this in a way my grandmother would understand?" So I was showing him all videos, PPTs, and all medical information. But this question made me think. So informed consent isn't about using big medical words and jargons we understand. It's about genuine communication and care, what the patient want to understand and know. I want to warmly welcome our wonderful organizers who made this wonderful session possible. A special welcome to our distinguished speakers, Professor Robert B. Leflar, all the way from the Yang Ming Chiu Tung University, hope I pronounced it right, Taiwan, and one of our luminaries, Professor Omprakash Nandimath, Faculty of Law from the National Law School, Bangalore. And we also have our own Dr. Ranjit Immanuel James, who will be talking to us about informed consent in the Indian scenario and UK scenario. And happy to have my colleague, Dr. Suganthi Iyer, and of course the Kaho torchbearers, Dr. Lallu Josepj, Dr. Suvin Shetty, Dr. Anna Judge, and Dr. Danya Michael. A warm welcome to all of you for this evening deliberation, and also to all our delegates who have joined today on this special day. Welcome to all of you. Informed consent has come a long way from being just a signature on a form. So today it's about building trust, ensuring understanding on both sides, and making our patients true partner in their healthcare journey. So as we go into this wonderful webinar, let's keep the discussion lively and interactive. And after all, the best learning happens when we share experiences and learn from each other. So thank you for joining us, and let's make this memorable Doctor's Day a wonderful learning experience together. Once again, a warm welcome to all of you on behalf of Kaho. Thank you.
Thank you, Dr. Frederick. That was an inspiring opening. Now let's hear from Dr. Anna George, Head of Quality at Aster India, who will introduce Kaho, its mission, milestones, and vision of the safer healthcare.
Thank you
Over to you, Anna.
Thank you so much, Danya. Dr. Nirmal sir, always a pleasure hearing you. And what a privilege to be in the midst of people whom we have grown up reading and listening to. Suganthi ma'am, we have grown up reading her articles, and Professor Nandimath was actually my own teacher when I did my PGDMLE National Law School, and all the other great speakers here today. So my job today is actually to introduce CAHO, and that itself is a privilege because we are all still students at CAHO, and to be given this opportunity to introduce CAHO itself, want to thank the CAHO leadership for the same. So as you can see, CAHO is not just one person, but it is people across the country, and you can see all of them standing there who are members of the governing committee of CAHO. So CAHO is a non-profit organization, as you all know, dedicated to promoting patient safety, quality, and accreditation in healthcare, and holds a lot of structured training programs with the basic aim at imparting knowledge and skills to healthcare workers and administrators. CAHO has had many training programs and so far have trained more than 50,000 clinical, non-clinical healthcare professionals with over 51 program courses and about 650 plus workshops. It is also an institutional member of the International Society of Quality in Healthcare, ISQA, and Asian Society for Quality in Healthcare, ASQA. Can we move to the next slide? So it is a registered society established in 2013, and it's got, though the name says accredited healthcare organization, consortium of accredited healthcare organizations, it's not just for accredited organizations, any organization embarking on the journey of quality, safety, accreditation, and also for individuals who want to take that journey of quality and safety in healthcare. So open to all healthcare professionals as well as organizations. Next slide, please. So CAHO's core purpose and vision, as you can see, the mission statement is healthcare institutions, diagnostic centers, and individuals pool resources for common goals and participation in shared objectives. Our purpose is to work towards safer healthcare and add value for all stakeholders. Vision, to be an admired global leader and basically transforming healthcare quality and safety across the country. Next slide, please. So this is the CAHO model for improvement. We believe in empowering other people, and together we make it a better place. So capacity building, outreach programs, evidence-based research, patient empowerment, and key collaboration with different industries across the country is what we are aiming at. Next slide. And this is the team, the central team, the main governing team leaders on top, as we have Dr. Vijay Agarwal sir, the president of CAHO, Dr. Lallu Joseph, the Secretary General, Dr. Shankar Sen Gupta, the Vice President of CAHO, and Dr. Naren Sehgal, who is the Finance Secretary, followed by a lot of other state level and vertical heads that we have, 3 verticals, as you know, hospitals, diagnostics, as well as quality professionals. Next slide, please. So these are many academic programs that we have. This itself one of the webinars, workshops, master classes, continuing quality education series, and a lot of other training programs and workshops. Next slide. So we encourage all of you to join the CAHO family. The benefits are huge in terms of networking, in terms of improving on our knowledge, meeting a lot of different stakeholders and learning from the best. Thank you so much. Oh yes,
Thank you, Anna.
discount for individual member for CAHO lifetime. So usually lifetime membership is a one-time thing, and we're just sharing this information with you on the occasion of CAHO Foundation Day. So we encourage all of you to join. You can just scan the QR code and register. Over to you, Dhanya.
Thank you, Anna. Now let's dive into the heart of our discussion, perspective on informed consent from around the globe. To start off, please welcome Professor Robert B. Leflar, a Fulbright Scholar, Abt Fellow, and Harvard-trained law professor. Professor Leflar has taught at Cambridge and Tokyo, a global authority on comparative tort law and health policy. He has published over 40 scholarly articles and served on US Supreme Court bar. We are honored to have him share his transnational perspective on patient rights and consents. Over to you, sir.
First, let me say that I'm honored to be asked to be part of this inspiring Doctors' Day occasion. I want to give particular thanks to CAHO and also to Dr. Ranjit James. I will say that this is an auspicious beginning to my planned stay in India for research on healthcare issues next year in 2026. And I will look forward, I hope, to meeting many of you in person when I am in India next year. Now, thank you for the very kind introduction. As an outline of the presentation, first I want to spend a few minutes on development in informed consent law and practice in the United States for background. Then, since I have become rather familiar with issues in Japan during my stay at the University of Tokyo, I want to present something on developments in informed consent in Japan, which I hope you will find rather interesting. We will move from Japan then briefly to Taiwan, where I am now teaching at the law school there. And then developments in two of the British Commonwealth nations, Canada and Australia. And finally, I want to briefly summarize declarations from two major international organizations on the subject of informed consent. And I will do this briefly because we have many fine speakers, including Dr. James, coming to follow, but I'm very happy to take your questions and comments afterwards. So, developments in informed consent law and practice in the United States. The earliest case which laid a foundation for all the rest was the Slowendorf case by New York's highest court in 1914, more than 100 years ago. And in that case, New York's highest court noted that every human being of adult years and sound body has a right to determine what shall be done with his own body. The most recent case, I say recent, although it was 50 years ago, most influential case in the modern era, it was Canterbury versus Spence, 1972. The facts of that case may interest you. Mr. Canterbury had a laminectomy that ultimately resulted in partial paralysis, which was a risk of which he had not been informed by Dr. Spence. The Canterbury court held that true consent to what happens to one's body is the informed exercise of a choice, and that entails the opportunity to evaluate knowledgeably the options available and the risks attendant upon each. Now, the Canterbury court laid out the two major approaches in American courts to that time. The Canterbury court noted that the majority of courts have made the duty to disclose options and their risk depend on whether it was the custom of physicians practicing in the community to make the particular disclosure to the patient. And this court disagrees. This court said, we do not agree that the patient's cause of action is dependent on the existence and non-performance of a relevant professional tradition. We hold that the standard measuring performance of that duty by physicians, as by others, is conduct which is reasonable under the circumstances, which is a test focusing on not only the physician's expert knowledge, but also on the patient's views. That famous decision gave rise to a split among the 50 states of the United States between two major approaches to informed consent: the traditional physician custom rule and the patient-centered rule introduced by the Canterbury Court. In the United States, each approach prevails in about half of our 50 states. And that fundamental dichotomy exists today, not only among the states of the United States, but also among the nations of the world. And I hope to give you some illustrations of how that conflict has played out in several of the major nations. First, a little bit of basic law from the United States on informed consent, what a patient must prove for an informed consent claim to succeed. First of all, The medical procedure carried a specific risk that was not disclosed to the patient. Second, the physician violated the applicable standard of disclosure, whatever that standard may be. The jurisdiction may have adopted one approach or the other of the two major ones. The undisclosed risk materialized. Fourth, failure to disclose the risk information caused the patient's injury. Causation, as we will see, is a major difficulty in many cases. The patient has the burden of proof on that causation issue in most circumstances. So the patient must show to win a case that he or she would not have undergone the treatment if that risk had been disclosed, and that foregoing the treatment would have resulted in a better outcome. Otherwise, there's no proof that the failure to disclose the risk caused any harm. Now, here's a particularly difficult point that courts wrestle with. What if the ordinary reasonable patient would have agreed to the treatment whether or not a remote risk was disclosed? However, this patient claims that he or she is highly risk averse and wanted to know about every risk, however remote. How should a court deal with the causation question in those circumstances? Now, here are the limits to the duty to disclose, and I think these limits are pretty much universally accepted across every major nation. First, common knowledge. There's no duty to disclose risks of which persons of average sophistication are aware. Second, patient knowledge. The patient cannot win an informed consent lawsuit based on the physician's failure to disclose a risk already known to that patient. Third, emergencies. There's no duty to disclose information in an emergency situation where the patient's not competent, immediate treatment is required to prevent more serious harm, and no substitute decision maker, such as a spouse or other family member, is available. Fourth, and this is controversial, the therapeutic privilege. There is no duty to disclose information where the disclosure process would foreclose rational decision or pose psychological damage to the patient. And that's an area about which courts disagree about the proper lines to draw. The burden of proof is on the doctor rather than the patient as to that issue. Then there's the issue of waiver. Some patients don't want to hear the details. Some patients say, never mind the details, doctor, you just do what you have to do. And in that sort of situation, the patient has waived his or her rights to information, and that waiver of information should be respected. So those are limits on the duty to disclose. I've been talking about a case that's 50 years old. Now, what about the internet revolution? What are some of the impacts of that on the current informed consent situation? Well, the Canterbury Court said that the patient's dependence upon the physician for information affecting his well-being in terms of contemplated treatment is well nigh abject. The patient then was essentially totally dependent on the doctor for information. That's no longer the case. Things have changed. With the near universal online access in most of the world, the imbalance of information between patient and physician has radically diminished. The levels of common knowledge and of personal medical knowledge by well-educated patients has risen considerably. On the other hand, and this is a caution, the level of misinformation through irresponsible social media platforms has also multiplied. And as a personal matter, personal opinion, I will say that much of this medical misinformation has been amplified by our current United States President, Mr. Trump, and his allies. More on that if you like. That unfortunate rise in misinformation places even greater responsibility on physicians, who now have both access to worldwide developments in medicine and the responsibility to be familiar with those developments. When I awakened this morning, I went online and I saw that Microsoft is now making a claim that its new AI platform, which it intends to open to the world before very long, is 4 times more accurate than information from doctors generally. I don't know whether that's true or not, but it's an example of where the internet revolution and AI may lead us. Now, let's turn to Japan. Informed consent developments there. Traditionally, Japanese medicine was paternalistic, and here are some stereotypical examples. Hakui no Kami, the god in the white coat, seeing his patients for 3 minutes each after the patients have been waiting 3 hours in the waiting room, dictating the patient's course of treatment without giving the patients any choices or indeed any explanation whatever. In case of a cancer diagnosis, covering up the diagnosis from the patient and enlisting the patient's family in the deception to keep the patient from losing all hope and perhaps committing suicide. Viewing any request by the patient for information about the treatment course as an impudent intrusion into medical matters, rupturing the trust relationship between doctor and patient. The concept of informed consent was so alien to Japanese practice that there was no phrase encompassing it in the Japanese language. So the standard term now in Japanese is the anglicized words informed consent. I will say, though, that recently Japanese law and practice have gradually converged with nations that have adopted a more patient-centered approach. Here are several examples. First, brain death and the organ transplantation law. The concept of brain death was highly controversial in Japan. There was a notorious case in which a cardiac surgeon declared a drowned swimmer to be brain dead and extracted his heart. He attempted to do the same thing that Dr. Christian Barnard had done in South Africa a couple of years before, and to be the first non-South African doctor to accomplish that, but he was unsuccessful. And the patient died, and the surgeon was convicted of murder. Took a long debate, but Japan finally enacted its organ transplantation law. On the one hand, the law gave official recognition to the permissibility of employing brain death as a criterion for the end of human life, which improved the quality and number of organs available for transplantation. On the other hand, incorporation of the informed consent principle was central to the political compromise that enabled the law's enactment. Part of that law said that to be declared brain dead, there had to be evidence that the patient had agreed to the use of brain death criteria on him or her. So there had to be informed consent to the use of brain death criteria. At least that helped legitimate the informed consent idea in Japanese medicine. Second example, strengthening patients' rights in clinical drug trials. The Health Ministry's good clinical practice rules gave patients' rights priority over acquisition of knowledge. And one reason is that the Japanese pharmaceutical companies wanted to sell their drugs in the United States, in Europe, other major countries. And in order to do so, they had to bring practices in Japan into conformity with the international harmonization of pharmaceutical standards. They had to provide for informed consent to their patients. Four other examples. The disclosure of cancer diagnoses is now standard in Japanese practice. The Japanese Health Ministry initiated various forms of recognition of patients' rights. And the main thing is in their point fee system by which doctors are paid, the Health Ministry now gives doctors credit for providing informed consent, and money talks. Japanese Medical Association, for example, reversed its previous position and said patients have the right of access to their medical records. And there was an interesting case, judicial movement toward recognition of patients' rights in the Jehovah's Witness case. And in that case, you had a lady who was had cancer, serious cancer. Her lifespan was estimated at 2 or 3 years. She underwent surgery, and unfortunately, there was excessive bleeding during the surgery, so she received a blood transfusion. However, she was a Jehovah's Witness, had not been informed of the possibility of a transfusion, and brought a lawsuit claiming that her rights had been violated. Well, she lived, the operation was a success. She lived for more than 5 years afterwards, to everyone's surprise. But she brought the lawsuit. It went to the Japan Supreme Court, and the Supreme Court declared that her rights had been violated. There was a dignitary interest apart from physical harm, and it's worthy of protection. And so that went beyond American precedents and showed the Japan judiciary's acceptance of a broad definition of patients' rights and informed consent. Now, quickly on Taiwan, Taiwanese informed consent law is summarized in this information from Taiwan University Hospital. Participation in medical treatment. Our medical staff should inform you or your family members regarding your health status, results from important tests, treatment plan, alternative treatment, possible outcomes, possible risks. We encourage you and your family to participate in the treatment and decision-making processes. You have the right to refuse or accept treatment or medical care provided by our physicians. We respect your right to look for a second opinion. You have the right to participate in medical decisions concerning surgery, invasive tests, treatments, anesthesia, blood transfusion, other high-risk treatments. Our physicians will inform you of the reasons for undertaking the procedure, the possibility of success, possible complications and risks, and alternatives. If the patient is unconscious or unable to communicate his or her wishes, we will explain the circumstances to the legal representative or other legally authorized person to obtain their consent. According to the Taiwan Medical Care Act, emergency treatment may be administered without consent in life-threatening conditions. So Japan and Taiwan are both civil law countries. Let's turn quickly to consent developments in two British Commonwealth nations, Canada and Australia. In Canada, 1980 case called Ribble versus Hughes ruled to allow expert medical evidence to determine what risks were material and must be disclosed and what risks were not material would be to hand over to the medical profession the entire question of the duty of disclosure, including whether there was a breach of that duty. What the doctor knew or should have known that the particular patient deems relevant to a decision whether or not to undergo prescribed treatment, equally to his duty of disclosure, as did the material risks recognized as a matter of required medical knowledge. The materiality of non-disclosure of certain risks to an informed decision was a matter for the trier of fact, in Canada, the jury, a matter which there would probably be medical evidence, but also other evidence from the patient or other member of his family. So we see there that Canada has adopted a patient-centered position on informed consent. And the same is the case in Australia under Rogers versus Whitaker. The claimant could see only out of her left eye. She had an operation on her right eye to restore that eyesight. Due to sympathetic ophthalmia, a rare occurrence of which she had not been warned, her left eye too was blinded. And the court ruled the law should recognize that a doctor has a duty to warn a patient of a material risk inherent in a proposed treatment. A risk is material if, in the circumstances of the particular case, a reasonable person in the patient's position, if warned of the risk, would be likely to attach significance to it. Medical practitioner is or should reasonably be aware that the particular patient, if informed of the risk, would likely attach significance to it. this duty is subject to the therapeutic privilege. So both Canada and Australia focus on whether the particular patient who may be risk averse and wanting to know all possible risks would find the risk in question a material risk. So Australia too has adopted a patient-centered position on informed consent. Finally, let me mention these two major international organizations' declarations. World Health Organization says patients have the right to be fully informed about their health status, including the medical facts about their condition, about the proposed medical procedures, together with the proposed risks and benefit of each procedure, about alternatives to the proposed procedures, including the effect of non-treatment, and about the diagnosis, prognosis, and progress of treatment. Information may only be withheld from patients exceptionally when there is good information to believe that this information would, without any expectation of obvious positive effects, cause them serious harm. So that's a limited therapeutic privilege. Patients have the right not to be informed at their explicit request. That's the waiver. In the World Medical Association, the patient has the right to self-determination, to make free decisions regarding himself or herself. The physician must inform the patient of the consequences of his or her decisions. A mentally competent adult patient has the right to give or withhold consent to diagnostic procedure or therapy, have the right to information necessary to make his or her decisions. The patient should understand clearly what is the purpose, test of treatment, what the results would imply, and what would be the implications of withholding consent. The patient has the right to receive information about himself or herself recorded in any of his or her medical records, and to be informed about his or her health status. So there we have an overview of recent developments in the United States and in several other countries about the progress of informed consent decision-making. And I, once again, stress that I am honored to have the chance to talk with all of you all. I'd be happy to answer your questions. And now let's open the floor for Dr. Ranjit James. Thank you very much.
Thank you so much, Professor Robert. It was a brilliant session. Now, to explore the Indian legal context around the informed consent, we invite Dr. Ranjit Immanuel James. Dr. James is an associate professor at CMC Vellore, Department of Forensic Medicine. He's a leading voice in legal medicine. He has been an expert reviewer for National SOP on Informed Consent published by Institute of Medicine and Law. He's an editor for legal medicine segment of Kaho's Spark magazine. His research spans forensic pathology to health law, with over 45 publications and awards to his credit. Over to you, Dr. James.
Thank you, Danya, for this kind introduction. Yes, system is the extension of the common law system of England, and we do have some personal laws governing matrimonial issues and some elements of civil law system as well in terms of impetus to codify certain issues. So predominantly we are a common law system, which is an extension from England. Now, with regards to informed consent, the basis is from the Article 21 of the Indian Constitution, which guarantees the right to life and personal liberty. The expression personal liberty under the Article 21 of the Indian Constitution is of widest amplitude and covers a wide variety of rights, including the principle of autonomy. And in the case of Puttaswamy versus Union of India, it has been established that the right to privacy is enshrined within the ambit of the Article 21 of the Constitution, enabling individuals to retain and exercise autonomy over their body and mind. Also, in the case of Common Cause versus Union of India in 2018, the Apex Court reiterated that the right to privacy protects decisional autonomy in matters related to bodily integrity. So apart from this basis, the criminal courts also define consent. And then our regulatory body also has given some insights as to about informed consent in medical practice. We have a Consumer Protection Act, which we are governed by after the Indian Medical Association versus VP Shanta's case in 1995. they also have some elements to talk about in terms of informed consent. And finally, the judgments, the High Court as well as the Supreme Court judgments also refine and influence the consenting approach in India. We have some elements of consent defined in Indian Contract Acts as well. So as I said, the BNS section 28 talks about consent in a negative context. That is to say that what is not a consent has been defined under section 28 of the Bharatiya Nyaya Samhita 2023. The main debate surrounding informed consent deal with principles such as autonomy and non-domination, personal integrity, and prevention of abusive conduct. So if we see the ingredients of informed consent, it has three elements. One is competency. The patient should be competent enough to give the consent, and he or she should have received the material information by which they can take a decision of themselves, and that consent which they give should be of voluntary nature. It should not be a coerced one or obtained by a fraudulent nature. The interpretation of informed consent has stand on various factors of material information disclosure and the extent of disclosure and so on. Though it is agreed that certain minimum standards of informed consent must exist, it is generally the case that the medical ethics places a higher standard of compliance than medical law. With regards to this materiality of information which the patient needs to be known, it is from the patient's perspective, not from the doctor's perspective. So as it was rightly pointed out by Professor Robert when he was explaining about the Canterbury case in the USA. Now, there are several models of informed consent. The traditional model is the paternalistic model, wherein the patients are excluded from active participation. Then came the prudent patient model or informed patient model, which prohibits physician not only from making decisions, but also giving their opinion, which will sway the patient's decision. So while the patients, especially in India, while the patients feel comfortable being empowered with the knowledge regarding a disease, many are not comfortable about taking the responsibility of making decisions on treatment, as they do not have a systematic and structured approach to reduce the treatment options. So informed patients who have choices may still prefer not to make decisions on treatment, which may be prevalent in Indian scenario. So the consumerist model, which we can equate with the prudent patient model, though it is a welcome change that influence the paternalistic model is waning, its replacement may not always be conducive to rational choices. Considering the disadvantages of decision making solely in the hands of either physician or the patient, it might be wiser to adopt to a cooperative and shared model of decision making, which is called the shared decision making process. Few experts suggested this, wherein both the doctor and the patient comes together and then share their information and knowledge, and then reach a consensus, and then they take a decision to agree to proceed with the decision that they have taken. Now, let's just quickly look at this chart, which is a self-explanatory chart. I will just try to equate this and draw parallels for the discussion what we are having now. So following the birth of the Bolam test in 1950s, which for years defined the standard of care in diagnosis and treatment, there was no specific test or procedure which kind of assess the advice component, which involves informed consent process. Then came the Montgomery case in 2015 in the UK, where it established the test, Montgomery test, which assess the doctor's duty to disclose information, material information to the patient. Though several, after the Bolam case in 1957, several countries have shifted from the doctor-centric to the patient-centric model, the Montgomery case achieved notable global recognition and influence. So if we have to draw parallels for an Indian scenario from this Montgomery test, let's just say the Montgomery test stage 1 says that was the relevant and material information not communicated to the patient. So there was this case, in the National Commission where the patient had undergone orthopedic surgery, which resulted in 1 to 2 centimeters of limb shortening. When he then put an allegation saying that the doctor has negligently treated him, so that he has suffered this harm. Then when the court, tribunal checked the medical records, they found the informed consent form where they talk about the complications column were left blank, whereas other details have been filled. So the court has assumed that the complications or the risk associated with the procedure has not been explained to the patient. Hence, they found that the hospital and the doctor guilty of negligence. Whereas the stage 2, we talk about was the doctor in possession of that information. So, Danya, can you hear me? Case, I think the NLSU Bangalore team under the mentorship of Professor Nandimath, who is here with us for the panel discussion, and the IMA Trichy chapter has developed a comprehensive consent form. In that, they have added one clause, because in the Samira Kohli case, the main issue is that the consent was given for diagnostic laparoscopy, but the doctor went and did a therapeutics operation, which was considered a breach of, privacy. So the court held the doctor and the hospital negligent. So to circumvent that, they have added one particular clause in that comprehensive consent form, which they have developed to give the option to the patient as to what they would like to do if at all, the treatment plan changes during the course after their initial consent. So that was the I was told that many professional societies in Trichy has adopted this particular consent form, which is being prevalently practiced in the particular zone. And in the Consumer Protection Act, if you see the old Consumer Protection Act, deficiency of service doesn't mention anything about material information. Whereas the new Consumer Protection Act in 2019 has talked about the deliberate withholding of relevant information by such person to the consumer is considered as a deficiency in the service, according to the Consumer Protection Act. So now, what is this material information which the Montgomery talked about? The court in Montgomery placed emphasis on the duty to warn not only of the risks inherent in the proposed treatment, but also of any reasonable alternative or variant treatments. Then the recent case in UK Supreme Court, there's a McCullough case, where the debate is that how far this obligation should extend was precisely the issue in McCullough. In McCullough, the Supreme Court has taken a view that it falls within the ambit of professional and clinical judgment, allowing the doctor to decide and apply the Bolam test while scrutinizing the standard of disclosing the reasonable alternatives to patient. Hence, the argument is that this verdict significantly restricts the scope of a patient's right to be informed, and McCullough redrew the line in clinical negligence, attracting a huge criticism for artificial fragmentation and paternalistic approach. So what they have said is that inherent risk, we will follow the Montgomery, but in terms of disclosing the reasonable alternatives, we will leave it to the clinical judgment of the physicians. So they have divided these segments and then taken a paternalistic view. For that, there were a lot of hue and cry among the scholars. Now, the evolution in a snapshot, most of which Professor Robert has already talked about. So I'll just quickly skim through this. The Scottish equivalent of Bolam is the Hunter versus Henley case in 1950s, and the Canterbury case, which took the patient-centric view. Whereas in 10 years later, in Sidaway case, the same issue was brought up before the UK Supreme Court, UK courts, and where they have taken that the risk disclosure is the clinical judgment, how much to disclose and all those things comes with the perspective of a doctor. So they've taken something opposite to that of the Canterbury's view. While the Rogers versus Whittaker case, the Australia rejected the Bolam test, and then they have taken a patient-centric view. Bolito case, we all know that it is just an additional layer of qualification which is given for Bolam test when somebody is assessing the standard of care delivered to the professionals, doctors. In the 2004 Chester versus Afshar case, the court has taken a U-turn, and then they have sided with the Canterbury view of patient-centric view, that the risk should be disclosed to the patient and it should be a patient-centered view, similar to that of Canterbury. And in Malaysia also, again in 2006, they have taken a different patient-centric view. And in Samira Kohli case in 2008, the Supreme Court talks about real consent concept. And the last segment where with the Canada case and Montgomery, Singapore case, as well as the McCullough case, all these cases talks about the material info disclosure. So out of this, the McCullough is the one where the retreat happened from the progressive approach taken in the Montgomery case. However, the Dixon and the Singapore case, they have added additional segments to the material information apart from what has been prescribed in the Montgomery case. So if we look at it, the initial view from the 1950s, it was predominantly a doctor-friendly or doctor-centric. Later on, the shift happens, and then now more and more patient autonomy is given weightage, and then the informed consent has evolved from 1914 to 2023, as far as we can see in the slide. Now, what as a clinician or what as a doctor in India who is practicing in India, what should we do? What should we, we have discussed various countries' expectations and things with the stands. So what do Indian courts tell about how much to disclose to a patient? That's the crux of the discussion. The quantum of information to be disclosed is not fixed, but the Supreme Court in India, in the Samira Kohli case, has given the medical professionals the discretion as the court believes it falls within their clinical skills and judgment. The primary reason for the Supreme Court's paternalistic and protective attitude towards doctors and the medical profession seems to be due to the nature of polity and society. So unlike many other cases of law where Indian perspectives often align with changes in the UK, the doctrine of informed consent is an exception. In 2008, the prevailing economic and societal views in India hindered the adoption of more progressive approach to informed consent. We are 17 years later now. If the courts were to reevaluate this doctrine of real consent concept and to side with the Bolam and Sidaway case of UK rather than the prudent patient model of the Canterbury, I'm not sure what position they would take. And finally, before I conclude, I would like to say we have a looming threat ahead of us because in the Vinod Khanna versus R.G. Stone case, National Commission has questioned the pre-printed consent forms and considered them as unfair trade practices. I believe the matter is pending before the Honorable Supreme Court. We are yet to hear from the Supreme Court as far as my knowledge goes. So take home points. As far as India is concerned, the Supreme Court has acknowledged the real consent concept of UK, where the doctors are given the privilege to customize the information based on the patient's need, not just based on the doctor's perspective, but based on the patient's need. We have the freedom to customize the information which should be adequate for the patient to decide, take a decision. And documentation is crucial because in the Jesus John case, what we discussed is that the column was left blank and the court took a differing view saying that the doctor is held negligent. Because in civil litigation, usually the standard of proof is balance of probabilities. So if the court feels the probability of the doctor would not have explain things to the patient, then the court will take a stand with the patient. So that is why we are reiterating that documentation, whatever we have explained, documentation is crucial. Okay. Thank you very much for the time and sorry for the technical glitches from my side.
Thank you, James. From legal theory to clinical practice for that critical overview. Now, let's turn our attention to a vital part of patient safety, that's on blood transfusion safety. It's my pleasure to invite Dr. Aparna Jairam, Chairperson of Diagnostic Division of CAHO, to present an overview of the white paper titled From Evidence to Action, Promoting Blood Safety Through NAT in India. Over to you, Dr. Aparna.
Yeah, I think I wish to, first of all, wish all of us on today's Doctor's Day a very happy Doctor's Day. And I think we all honor this profession with dedication, compassion, and tireless commitment towards patient safety. I am glad and I would love to I would like to thank Lallu Madam and Vijay Sir for always motivating me to look forward to coming up with something so unique. And really, I'm grateful to LJ. So this is our white paper, which we came up with something like, in India, I think most of us, if you look at the blood banks, which are there in tier 1, 2, and even in 3 cities, most of the places, HIV, the most important serological marker, HBsAg and HCV, are still being done by ELISA and TriDot. And NAT testing is the necessity today. And we could do this study with the help of Roche, our IVD partner, and we had experts from across our country helping us to come up with this white paper. And how lucky we are that it has just come out and we are launching it today on CAHO platform. So I'm glad, and I would really like to share this link with everybody at our CAHO family. And I'm sorry for the disturbance around me, but yes, it's a proud moment for us. So we are promoting blood safety, which indeed will help for patient safety through NAT testing, that is nucleic acid testing. I will request Preeti or my teammates to share the link of the same. I understand the concern of the time and would end it by wishing everybody a happy Doctor's Day. And thank you, LJ and Vijay sir, for this opportunity. Thank you.
Thank you, thank you, ma'am.
Thank you,
Now
AD.
Now it's time for panel discussion moderated by the dynamic, ever-committed Dr. Lallu Joseph, whose name has become synonymous with patient safety and quality. Joining the panel, we have Professor Omprakash V. Nandimath, a professor of law at National Law School of India University, Bangalore. Sir was a former registrar for the same university as well. His areas of expertise include medical law, business law, tort, environmental law, and banking law. He has served as a visiting faculty at Warwick University and Cardiff University in UK. He is a Fulbright Fellow and Stegner Fellow at University of Utah. Professor Nandimath has several publications to his credit. We welcome you, sir. Dr. Adil Khan, founder of Tulu Health and Thank you, sir. Dr. Adil Khan, founder of Tulu Health and Stanford India Biodesign Fellow, is a digital health visionary. His AI platform redefines the patient engagement, and he has developed Shape IU Health Tech Roadmap across more than 150 hospitals in India. During the pandemic, Sir has also co-developed patented ventilated PPE and has also contributed to the national health policy initiatives like ABDM and HCX. We are happy to have you here, sir.
Thank you. It's my pleasure to be here and yeah, looking forward to the discussion.
Thank you, sir. And Dr. Suganthi Ganapathy Iyer, a medical legal expert and director at Hindutva Hospital, Mumbai, with qualifications in both medicine and law. She's a principal assessor for NABH and convener of IMA Mumbai Medical Legal Cell. Her teaching and policy roles make her a bridge between the clinic and the court. Thank you for joining us today, ma'am.
Thank you so much for the nice words and generous words. Thank you.
Okay. Dr. Parivalavan Rajavelu, an esteemed surgeon and founder of Skill4Med, is widely respected for advancing surgical education and bridging the knowledge gap through hands-on innovation. We welcome you, sir.
Thank you. Thank you, Dania.
Over to you, madam.
Thank you. Good evening, and thank you very much for joining us today. Happy Doctors' Day. It's indeed a pleasure having all of you at this time around 7 p.m. Indian Standard Time. And congratulations to Dr. Aparna Jairam and the Roche team for launching the most wanted white paper of CAHO. We will be circulating that very widely. I would like to, really start this panel discussion with my thoughts on consent. We all know that I think Dr. Nandimath's audio is on. Nandimath, sir? Yeah. So when we all embarked on this exercise of NABH in the year probably 2007 and 2008, I just cannot imagine the kind of concerns that we were using at that point in time. I look back today at some of the concerns that we were using in my own hospital, just about 3 lines there, nothing at all. We have come a long way, and thanks to our accreditation bodies and professionals like all of you who have brought in so much of awareness about the importance of consent and how good consents can actually protect us. It is not just about defensive medicine, how to protect oneself, but also educating the patients and doing the right thing for the patients. With that in mind, without much time, I would like to pose my first question to none other than Professor Nandimath. Nandimath, sir?
Yes, I am here, ma'am.
Yeah, thank you. This is a very interesting question on parental refusal versus child's best interest. How should doctors respond when parents refuse life-saving treatment for a child? What role does the legal doctrine of parents' play in protecting the child's best interest? If you could elaborate on that, sir.
Yeah, thank you, ma'am. It's a really tricky question, which is actually being framed. See, there are 3 basic interests that actually compete. And the doctor has to really balance these 3 competing interests is what I would like to say at the very outset. The first interest is the child whom the doctor wants to save, because you have made it very clear it is a life-saving treatment. If the treatment is not given, the child will probably die. So that child has obviously the right to life, as we say under Article 21 of the Constitution. Otherwise, also doctor wants to. This is the first interest. The second interest is the parents' autonomy as a proxy to decide on behalf of the child as natural guardians who are resisting for that treatment. That is a second interest which the doctor has to keep in mind. The third one is the doctor's interest himself, where ethically he has been trained and he has been motivated to help. And he knows if he helps, probably he would save the precious life of that particular trying to say these are the three very important competing interests. So now how the doctor needs to balance them. Strictly, if we go by the law, there is one particular law which we have in India, that is Juvenile Justice Care and Protection of Children Act 2015, where any child who is neglected, and this comes under the permit of neglected child, and parents are not in a position to take a good decision, at that time, the doctor can go before the Child Welfare Committee constituted under that law, and they can probably intervene and try to help the cause if there is a time. Let's say there is no time, the doctor can boldly use another very interesting privilege what he has. In common law, which is the prevalent law in India, which very clearly says, if you are, what should I say, if it is a medical emergency, the doctor can treat the patient without waiting for the consent. So if it is a medical emergency, he can go ahead. He can probably try to take that route if there is hardly any time for him. The third one, if he is part of a better establishment or progressive establishment, this is a word I generally use, where he has ethical committee for his well, he can sound the ethical committee and tell them that because of these reasons, he is undergoing, because it's a medical emergency, and he is going to treat without the consent, particularly drawing their attention to the parents' resistance to that treatment. So these all are the things. If the doctor is determined to treat the patient, this is how he can use the law. But I would rather say if the doctor himself is perplexed, which often is the case, he doesn't want to lose the child, but at the same time doesn't want to be a martyr for that. At that time, I would say the doctor should try to understand, these are the three competing interests, and if he can, he himself or with the able assistance can conciliate and try to bring some kind of a consensus. That is the best kind of a thing. But finally, you use the thing, Dr. Lallu, the doctrine of parent patry. That means a parental authority. But that parent patry or parental authority lies with the state, and it has to be exercised through the courts. So the doctor, he himself cannot really act as a parent patry and say, because of that doctrine, I am doing this. This is how I would formulate my response to this so-called tricky question, although it is not so tricky from your day-to-day clinical practice.
Wonderful. I think nobody can give clarity to this question the way you have given, sir. Amazing. So it is not, the parent patry is not actually the healthcare provider to execute. It is basically by the court. And
Yes.
here you brought it out very clearly that, you have the right to provide treatment during emergency without consent, number one. Number two, you could take advice of your clinical ethics committee. And the most important thing is you try talking to the parents and create the awareness, take the consensus and proceed. These are generally the three options, isn't it?
Yes, ma'am. Yes, ma'am. But anyway, I just would like to say, practically, you need to take a decision on the go. This knowledge of law would help you to act confidently. Although I would not advise the doctor to become a martyr only by acting on the right side of the law, because time is a very critical element there, is what I believe, Dr. Lallu.
Perfect, perfect. Thank you. Thank you so much, sir. Now over to Dr. Adil Khan. You know, we have worked very closely, Dr. Adil, and thank you so much for bringing the concerns online. We always believe that technology is a force multiplier, and today, along with Kaho, what you've created has reached so many hospitals and patients, the patient education material and the concerns. Now, all this is available online, and we really have not gone into digital concerns so far. We still take concerns in paper and probably scan them and keep them. So with that, with the introduction of the Digital Personal Data Protection Act of 2023, how is digital consent defined and protected in Indian healthcare? What safeguards are needed to ensure its legitimacy and security? First of all, is it agreed upon? And the second thing, what are the safeguards that are needed to ensure its legality and security?
Okay, thank you for that question about digital consent under the new DPDPA Act 2023. This is something that's fundamentally has changed how we practice medicine in India. I think many of my colleagues are still figuring out what this means practically. So let me start with a simple example from how it's going to look like. So just imagine a lady come in for a routine endoscopy. So in the old days, we would have handed her a generic consent form that basically said that we can do whatever we need medically. But now, after DPDPA Act, I, as a doctor, have to sit down and explain that, ma'am, we are going to record this procedure digitally, store the images in our computer system for 10 years, possibly share them with the gastroenterology specialist, and data might also be used for quality improvement in our hospitals. She had to actively agree to each of these uses, not just sign one blanket form. So here's what interesting is, like, she actually appreciated it. She will say, like, doctor, I never knew what happened to my medical record after I left. So that's transparency builds trust. Now, what exactly is digital consent under DPDPA Act 2023? Think of it this way, like every time we perform any medical procedure, from a simple blood test to complex surgery, we are creating a digital footprint. Like X-ray goes into PAC systems, surgical videos are recorded, and a lot of digital data is created as well. So a law now says that patient must know exactly what digital data we are collecting and how we are using it, and they must actively agree to it. The consent has to be specific, informed, and unambiguous. So instead of saying we may share your information with other doctors, we now say that we will share your MRI images with Dr. XYZ for a second opinion on your diagnosis. But let's be honest about the challenges. The biggest complaint I hear from a lot of colleagues and the hospitals that this is going to slow down everything. And yes, initially it does. But here is what I've learned, like technology is actually our friend here. As we have already in Kaho, we have implemented a digital consent platform, which is available in multiple languages. And even it comes with simple graphics and videos to show them what exactly that procedure is, and to educate them so that they can make a a well-informed decision of giving a consent. And that whole process won't take more than like 3 minutes. And you can show those, you can actually give that platform to your patients via QR code as well, if required. And for patients who can't read, we also have recordings of consent forms where they can just listen to those things to understand what actually they are signing. So now the key insight here is that different procedures need different level of consents. A blood test is much simpler than a cardiac surgery consent, and we have to tackle them individually and with respect to each procedure. Now, speaking of safeguards, this is very crucial. So hospitals need what I call triple protection, where we say technical safeguards like encryption and secure access controls for the data, organizational safeguards like staff training and clear protocols, and legal safeguards like proper documentation and grievance mechanism. And let me tell you why we are talking about this is because the penalties for getting this wrong are serious. We are talking up to 250 crores for security failures and up to 50 crores for invalid consent processes. But beyond penalties, this is about trust. When patients understand how their data is protected and used, they actually share more complete medical histories with us, and they rather more trust your organization with other things as well. So now I'll just ending this. So my message to all my colleagues is this: that don't see digital consent as a burden, see it as an opportunity to build stronger patient relationships. Yes, it requires some changes in our workflows. Yes, we need better technology and staff training, but ultimately this makes us better doctors and our hospitals better institutions.
Absolutely. I think you nailed it. And that's coming. And I think it's imperative. We just cannot hide away anymore. And certainly we have to have adequate safeguards and have all possible education about the requirements in a larger way. Today it is unclear, and I think a lot more educational drive will have to take place. Thank you so much, Dr. Adil. I'll now move on to Dr. Parivalavan Rajavelu. Sir, you've been a very strong proponent of concerns. We have heard several talks of yours about, concerns. You're a surgeon yourself. And, I'm just modifying the question that was put to Professor Nandimath. Again, it's a life-threatening emergency situation. So let's talk about in life-threatening emergencies where obtaining consent isn't feasible. How does the Indian legal framework guide medical decisions? What ethical responsibilities must doctors consider in such situations?
Actually, thank you, Dr. Lallu, for that question. The Indian law actually is pretty straightforward in this particular aspect. The section 92, actually says the implied or necessity consent in true emergencies. So if there is a patient who comes for an emergency and there is no immediate relative surrogate as defined by the law, then immediately available. I think the immediate is the key term here. Then the surgeon can go ahead and perform the surgery without a consent. The flip side of the coin is also this Supreme Court President, Paschim Banga 1996, which said that if you don't do it, it violates the Article 21 of the right to life. So in both ways, the surgeon is protected or sort of actually has a moral duty to do the surgery even without the consent. But what we need to really, there are 2 or 3 factors which we have to keep in mind. One is this consent is very, now in this exception to the consent, is very narrow. The time limit is very narrow and it is time bound. If at any point in time you were able to identify a surrogate, then this law doesn't hold good. So this could be argued that I was there, but you still didn't take the consent. So you got to be very, very careful about that. And should be strictly applied to save life or serious harm. It cannot be applied to any other form of any surgery which is intended for any other treatment. So if it is life-saving and it is going to really prevent the patient from obtaining serious harm, then only we can use this exception to the consent. And the last point is documentation. You need to document that you have done a proper search and still not found out anybody to sign the consent, and you should be able to prove it. And what we do in practice is to spread the responsibility. Instead of one consultant just saying that he can go ahead, a person of equal professional experience also consents, in the sense seconds that particular patient needs a life-saving surgery. So this is a way of spreading, though the law doesn't really mandate this. In practice, we do this to spread the responsibility and make sure if suppose any court is comes against us, we are protected. So that's what I would say about this to your question.
Yeah,
Basically, it's straightforward, but I think there are certain safeguards and certain things which we need to follow.
Certainly. I think that's very clear. So when you say that we are spreading the responsibility a little broader, Generally, hospitals tend to have a surgeon and another surgeon, or a surgeon and an anesthetist, or a surgeon and a senior nurse signing off. That's probably what it is. Though we don't define who should be there, we just say at least two people concur on a decision that it is a life-saving emergency and you're going ahead. That's what you mean, isn't it, sir?
Definitely. Yeah.
Okay, thank you. Thank you so much. Now I have my dear friend here, Dr. Suganthi Iyer. We have done several assessments together and worked very closely at NABH, and she's considered as one of the very senior medico-legal experts in the country. Ma'am, thank you so much for joining us today. This consent, this question is very specific to the video consent in practice and research. So is video consent legally valid in India? Is it mandated in clinical practice or research settings? And how widely is it accepted? Your thoughts?
Yeah, thank you so much, Dr. Lallu, for always this pleasant invitation. I really enjoyed the talks given by Dr. Robert, Dr. James. So thorough, so complete. And with regard to video consent, I would like to inform that the National Medical Commission, Registered Medical Practitioner, Regulations 2023 have included that video consenting can be done. So it is absolutely legal by the latest amended Code of Ethics of 2023. In fact, 2023 regulations are so different from the earlier one. There is separate paragraphs on consent. There are chapters of consent in the NMC Registered Medical Practice Regulations 2023, and all our doubts of consent have been clarified. Video recording is one of them. And of course, video recording is very specific about research. It is mentioned there also in the guidelines, and it's also mentioned about video consent recording for kidney transplant surgery, which is also mentioned in the THOTA Act 2013. So this video consenting for research is mentioned not only in the research law of 2019, but also in the code of the regulations 2023. So therefore, for research, it is valid. It is also valid for kidney transplant. But in both the cases, what is mandatory is that before we do the video consent recording, a consent for video consent recording itself should be taken. So it will be two consents. A consent that will be coming on the video, the recording is taken, number one. And for this is followed by that for the research, where you explain to the subject, get the assent, get the consent of the subject's legal guardian, explain about the type of research, what is the type of research, and explain, especially with the vulnerable patients, more so with the vulnerable patients. In research, you have to do it especially for the vulnerable ones, like pregnant, the immunocompromised, the children, the people who are not really conscious, etc. So those type of vulnerable patients, etc. Students, we are going to do research. Employees, we are going to do research. So that category is specifically invited. And kidney transplant with effect from 2013, it is there not only for the uro counseling or gastro counseling, where initially it's a separate form where the doctors and the patients have to sit across, explain and show the videos about the procedures, explain the benefits, consent, the risk, etc. And the patients can ask questions. So that is a separate session. And also video consenting for the authorization committee. So the hospital authorization committee again takes an interview for giving the approval. There also a video consent record has to be taken for the transplant cases, whether it's kidney or liver, etc. So here, and these have to be kept permanently in the hospital server or somewhere. These records have to be kept. Because if tomorrow there is an investigation, there's a complaint, either for the research, either for the kidney transplant, liver transplant, heart transplant, etc. These videos have to be surrendered to the police, to the director health services or any other authority which is in charge of the transplant. And they take the videos because the patients would complain that I was told it's a blood transfusion and the organs have been removed and transplant has to be done, etc. And this, again, this is then therefore a very medico-legal valid legal document. And when there is a complaint, more so criminal complaints are very common in all this. So these videos have to be really stored for really the period of storage is not mentioned, but in criminal it can be any time. So it has to be indefinitely stored. Even the appropriate authority can ask it anytime. So all this is fully legal and has to be stored indefinitely for a very long time period not mentioned under the act. So, you know, that really is a very query thing. So that is it. But another thing, what I would say, that these consents, whatever consent, whether implied consent, informed consent, all the thing which you have been listening for the last 1 hour, 15 minutes and over, being under the NMC regulations 2023, now this gives an option for the subject or the patients to approach beyond civil, criminal, human rights commissions, your consumer courts. Another thing is the Medical Council of India or the State Medical Council for invalid incomplete consents. So one more case where the doctors can face the problem is the Medical Council, where specifically there is a chapters and lines on consents, and therefore they can take about improper consent. So consent is becoming where 40% of the litigations was because of improper consent. Now even in State Medical Council, these chapters can be taken. So because of those paragraphs which are specifically things. And in fact, they have given specific typed consents, the way it has to be taken for telemedicine. That is one of the appendages. So whether in telemedicine, yes, it will be, you have to show the limitations about examination, etc. So, and you have to take it from the patient and, you know, your caregiver, etc. So all these are there. So one more forum where they can sue the doctors. I mean, it's a very sad thing that on Doctors Day have to mention this, but it's the Medical Council, and where even there can be a relinquishment of the degree or reprimand, etc. So that is the side effect. And so it is fully legal. This is what I would like to say. But one more battle, that is what I would like to say. So this is it. Thank you so much. And even the Montgomery, this thing of 2015, which Professor James mentioned, Dr. James, that is also included in the regulations 2023. Thank you so much for the opportunity, Dr. Lallu.
Thank you. Thank you so much, ma'am. We would certainly have loved to continue this conversation beyond. Unfortunately, due to want of time, I have to close with just 4 questions to each of the 4 experts who have come, taken the time. Certainly, you know, a great session, learning lots from all of you.
Team. Good evening, everyone. On behalf of COW Leadership, I extend my heartfelt thanks to each one of you for joining today's webinar on evolution of informed consent in medical practice and law, a global scenario, on the occasion of the Doctors' Day. So happy Doctors' Day to all of you who have joined us today. First, my sincere appreciation goes to our distinguished speaker, Professor Robert Leflar, for delivering such an insightful lecture. Your deep knowledge and practical examples brought clarity to the evolving nature of the informed consenting process. My friend, Dr. Ranjit James, delivered a wonderful and a well-structured presentation on the important topic of Indian scenario of informed consent. Extend my gratitude to our moderator, ever-inspiring, dynamic Dr. Lallu Joseph ma'am, who guided the session seamlessly and fostered the thoughtful discussions. Professor Omprakash Nandimath is a teacher to me, as well as many of us in the delegates in the audience. Dr. Adil Khan, a medtech guru who joined us. Dr. Parivalavan sir, thank you. A teacher par excellence. I have been student to some of his courses. Thank you, sir. And Dr. Suganthi Iyer, ma'am, guide to most of us in the fraternity. Thank you for joining us. Your perspectives enrich the conversation with added depth. Thank you all. The organizing team led by Dr. Ranjit James and Ms. Dania Michael, along with the COW Secretary, Meenakshi, Nisha, Preeti, thank you for your tireless effort behind the scenes to ensure a smooth and professional execution of this particular webinar. A special thank you to all the participants for your engaging attendance, truly enhancing the session and reflected your commitment to patient-centered care. Ensuring informed consent is not merely a formality, but a cornerstone of ethical practice. And participating in the COW quiz, though only 25 of you joined, but still thank you and congratulations to the winners. We hope this session left you with practical insights and new perspective that you can carry forward in your daily practical practices. Thank you all once again for being part of this wonderful dialogue. We look forward to welcoming you to our next event. Until then, stay safe, stay informed, and continue championing the patient's rights and ethics in healthcare. Thank you all. Good night.
Thank you.
Thank you.
Everyone, and happy
Thank you.
Doctors.
Happy Doctors' Day.